This is Barry Zalma speaking for Claim School Incorporated with an article about the law of unintended consequences and the tort of bad faith and how it applies to insurance contract law. In a typical contract, one party has a duty to perform, construct a building, deliver goods, convey real estate, pay indemnity, and the other party has a duty to pay money or perform a task. Breach by the performer may take the form of nonperformance, defective performance, or delay in performance. The primary purpose of damages for breach of contract is to protect the promisee's expectation interest in the promisor's performance. Damages should put the plaintiff in as good a position as if the defendant had fully performed as required by the contract. Damages should never provide a profit to the non-breaching party. Insurance, like all parts of modern society, is subject to the deprivations of the law of unintended consequences. In the USA alone, people pay to insurers more than $1.2 trillion in premiums, and insurers pay out in claims as much or more than they take in. Profit margins are small because competition is fierce, and a year's profits can be lost to a single firestorm, earthquake, hurricane, flood, or unexpected bad faith lawsuit. Neither the courts nor the governmental agencies seem to be aware that in a modern capitalistic society, a healthy and viable insurance industry is a necessity. No person would take the risk of starting a business, buying a home, or driving a car without insurance. The risk of losing everything would be too great. By using insurance to spread the risk among all the costs of taking the risk to start a business, buy a home, or drive a car becomes possible. The persons insured are dependent on their insurer to take the risk the insureds are not willing or able to take alone. Insurance contracts can be simple or exceedingly complex, depending upon the terms and risks taken by the insurer. Regardless, insurance is only a contract whose terms are agreed to by the parties to the contract. Over the last few centuries, almost every word and phrase used in an insurance contract have been interpreted and applied by one court or another. Ambiguity in contract language became certain. However, the average person saw the insurance contract as incomprehensible and impossible to understand. Ostensibly, to protect the public, insurance regulators decided to require insurers write their policies in an easy-to-read language of which some statutes call plain English. Because they were required to do so by law, insurers changed the words in their contracts into language that people with a fourth-grade education could understand. Precise language interpreted by hundreds of years of court decisions were disposed of and replaced with imprecise, easy-to-read language. The law of unintended consequences came into play, and instead of protecting the consumer with easy-to-read policy language, an attempt to force insurers to deal fairly with the insureds resulted in thousands of lawsuits. I've done this before. After creation of the tort of bad faith, if an insurer and insured disagreed on the application of the policy to a factual situation, damages were no longer limited to contract damages as in other commercial relationships. Rather, there would be a race to the courthouse. The insured whose claim was rejected in whole or in part would automatically sue for breach of contract and for the tort of bad faith. On the other hand, the insurer would file a suit seeking declaratory relief and a court's blessing that the decision to deny the claim was correct. Whoever was first to the courthouse made no difference. The insurer would seek to have its decision recognized, and the insured would seek tort damages, and including punitive damages. If the court found that the insurer was wrong, it could be required to pay the contract amount plus damages for emotional distress, pain, suffering, trouble, inconvenience, attorney's fees, and punishment damages. Often a creative plaintiff or court would also assess against the insurer other damages the insured and the court considered appropriate. The original reason for the creation of the tort of bad faith was the desire that the tort would have a salutary effect on the insurance industry and deter insurers from treating their insureds maliciously. When insignificant claims deemed wrongfully denied resulted in multi-million-dollar verdicts, fairness found a new definition. Juries unaware of the reason for and operation of insurance decided that insurers did not pay claims were evil and needed to be punished. Often judges and jurors would feel sorry for the insureds and decide to make them rich rather than just compensate them for their loss. Multi-million-dollar punitive damages judgments happened even when the insurer's conduct was correct and proper under the terms of its contract. Sometimes jurors would conclude the insurer acted properly, but that because of the way it reached its decision, it needed to be punished. The massive judgments were publicized heavily. Every punitive damage award was clipped from newspapers and websites across the country by policyholders' lawyers and sent to insurers with a settlement demand far above the value of their case. When insurers succumbed to the demands, they found that they accomplished little other than resolving a single action. The law of unintended consequences struck again. What those quick to settle bad faith suits, most of the massive verdicts were reversed or reduced on appeal, did not understand was that the insurers who acted in good faith were forced to raise their premiums to cover the payments to avoid the bad faith suits. The bad faith actors also raised their premium, but not as much as the good faith insurers, and lost little business because their premiums were less. They continued to act in bad faith, paid less to their insureds than their good faith competitors, and profited while those who treated the insureds in good faith lost money. The good faith insurers, faced with the massive verdicts, allowed fear to control reason, and even paid claims that were improper or fraudulent. The extra cost was passed on to all insurance consumers, not just to the insurers who acted improperly. The bad actors continued their wrongful acts and only paid the few insureds that sued after a long and contentious defense to the lawsuit. Honest and professional insurers paid fraud perpetrators and claims the policy never intended to cover for fear of being accused as being the same as the bad actors. Those who exercised good faith were punished, and those who dealt with the insureds in bad faith profited. The tort of bad faith, designed to help the innocent, resulted in punishing the honest and professional insurers, rewarding the insurers who acted in bad faith with profit. Also, because of the fear of punishment with bad faith suits, insurers allowed many frauds to succeed rather than face potential tort damages. Contract terms and conditions that were clear and unambiguous were ignored to avoid litigation. In the more than 70 years of application across the United States, the tort of bad faith has not, in my opinion, had a salutary effect on the insurance business or the people and businesses who are insured and need insurance to conduct their business. Insurance costs have increased more than is reasonable or necessary, so that sufficient funds exist to pay claims and tort damages from those insureds who believe they were wronged. Not all bad faith suits are certain winners. Not every bad faith suit results in a punitive damages award. In a first-party claim in New Jersey brought by the insured against its own insurance company, the appellate court concluded that to establish an insurer's bad faith, the insured must demonstrate that coverage was so clear it was not fairly debatable. If there's a valid question of coverage, that is, the claim is fairly debatable, the insurer bears no liability for bad faith. Insurers, in fear of a potential bad faith judgment, will face a plaintiff who needs to show the lack of reasonable basis for denying the claim or unreasonably delaying its processing and the insurer's knowledge or reckless disregard that it was acting unreasonably. Unfortunately, few insurers are willing to take a chance on convincing a jury that the decision to deny the claim was fairly debatable, or that the decision made was as a result of a genuine dispute. In Louisiana and Mississippi, for example, multiple millions were paid to settle claims that flood damage was covered as a result of Hurricane Katrina, although the policies excluded flood, and the plaintiffs insured failed to buy flood insurance. Mudslides in Southern California from hills denuded by wildfires, clearly excluded, are being paid because of fear of claims of bad faith and an aggressive Department of Insurance that construes a mudslide as a loss due to fire. This video was adapted from my book, It's Time to Abolish the Tort of Bad Faith, which is available from Amazon.com as a Kindle book or a paperback. If you found this video to be interesting or useful, please, as you watch it on Rumble, click on the Rumble button, or if you watch it on YouTube, click on the like button. Thank you for your attention.